Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. Solely for informational purposes, I will tell you that I am a professor at Mississippi College School of Law. But I tell you that only for informational reasons. All views expressed here are my own. Now let's get right to it. You know, this series is following my constitutional law class. And now we are in a very exciting part of the course. Students are preparing and presenting their position statements on current constitutional conflicts. Today we had 7 wonderful presentations. The students not only have to factually explain the conflict, but they also have to connect it in with the broader principles of constitutional law. Then guess what? They have to argue the other side before they argue their own. As good lawyers and as good citizens, a goal is understanding. And often we might be able to get closer to that understanding by looking at and examining the opposite position before we try to persuade others of our own. And that is a great skill for lawyers to develop. So they argue the competing position and then they present their own position. So go back and check out the other clips. This is day 4 of that process. And in the first, second, and third, I told you about those student presentations. But let me point out, these summaries are my interpretations of what they said. I take full responsibility for that. Now, the first student who presented today, I'm going to read to you what the student's position is. The student argued that governmental temporary restrictions on church participants' rights to physically congregate during an active pandemic do not violate the free exercise clause and are subject to the rational basis standard of review. So during COVID-19, there are a number of laws, executive orders, restrictions being placed on individuals, on businesses, and on other social and religious institutions. Some of those restrictions also are placed on churches and religious organizations. My student argues that those restrictions on churches are constitutional, although we do have what is called the Free Exercise Clause in the First Amendment of the Constitution. Now, this is her argument. Her argument says that in these difficult cases, the result often turns on how closely do we scrutinize government. Remember an earlier clip, you should go back and watch it. It says, what you're talking about government, that sometimes government is given great leeway, that all government has to have is a low level, rational basis. It doesn't even have to be wise. There's a presumption that what government is doing is constitutional under this low level. But sometimes we say, what you're talking about government, and we scrutinize government under a higher level of review called strict scrutiny, because we're wondering why government is treating certain groups unequally or why government is infringing on certain fundamental rights. So here, my student argued that the restrictions placed on churches during the pandemic ought to be evaluated under a low level of review. And you may say, wait a minute. Free exercise of religion, that's a fundamental right. Government should be evaluated on a high level review. What you talking about, government restricting how individuals can worship? But her argument is that sometimes restrictions placed on churches are being placed on them not because they are a church, but being placed on them as restrictions are being placed generally on other types of groups or businesses or buildings or occupancy restrictions. And when that is happening, and when churches are not being targeted while other groups are allowed to go forth, then you evaluate government with a very low level of review. And her argument is that that is constitutional, that those restrictions during a pandemic are indeed constitutional. I had some questions for her, and I emailed them to her, and I can't wait to see her reply. But my question was, what if government says there are certain types of events that are super spreader types of events, and these super spreader events for COVID occur when we are inside, when we are close together, talking, engaging, singing, shouting, teaching, preaching, hugging, laughing. And what if government says we think that it happens more frequently in churches? So what if government then frames it like a general law, but they are indeed targeting churches because they believe churches could be super spreaders for COVID-19? Would that be constitutional for government to be doing that without acknowledging that they are indeed targeting churches? And that's the question I posed to her, and I pose to you. I can't wait to see her answer. She did an amazing job. See, what we're doing in class, we're learning to value the positions and how well the positions are stated. In seeking justice, or at least seeking a taste of justice, I believe we have to learn to value opposite positions and to be able to articulate them better than the person who holds them. Once we understand that, then we will do a better job, perhaps, of persuading others of our own position. So she just did an amazing job on her position statement, and I can't wait to hear her reply to the questions. Now let's go on to the second one. The second student's position was Pandemic 2020, the constitutionality of state safety laws. While I do not think it wise to completely lift the laws, as public health is a top priority, a safe middle ground can be met. Now, this student also did an amazing job. As I watched her, I said, "You're trying to be a negotiator, are you? Are you trying to be one to stand in the middle and bring the two sides together?" Sometimes that middle position gets to be a little tricky. But here she argued that she wanted to acknowledge those who are concerned with their liberty or with economic interests. She acknowledged those interests as valid. Then she wanted to acknowledge those who are concerned with their safety and those who may be more vulnerable health-wise. She acknowledged those. Then she went in search of a middle ground that would give some to one side and some to the other in a way to make it through this pandemic. Oh, I had some questions for her. I did. And one of my follow-up questions was this. So if you're standing in the middle, that means you're not going to have a total focus on health and safety of, I won't say of one group, of everyone, but especially of those who are more vulnerable, as you attempt to open things more or open schools or what have you. So in a way, you're doing a trade-off. You're making a trade-off saying that certain individuals may get sick or what have you, they may get very sick, but you're going to stand in the middle and say, let that happen to some so that others can have their liberty and economic interests. And my question to her was, how does she balance those two? How do you balance? How do you balance liberty interests against lives? How do you balance economic interests against health? How do you stand in that middle place, which can be a very difficult place to be? I can't wait to hear her responses, but she also did an amazing job with her position statement. Let's go to the third one. The third student argued this: check your privilege at the bar. How the New York bar exams discrimination against out-of-state test takers violates the Privileges and Immunities Clause of the 14th Amendment. She made a very interesting argument, and one that our law students and law graduates are quite concerned about. So during COVID, we have individuals, we have graduates who are preparing to take bar exams. And last summer, especially, there was concern as to whether states would indeed allow the bar examination to go forward and under what conditions. So her argument is, well, she disagrees with what New York did. She says New York said, well, we're going to give preference to individuals who attended law school within New York. Individuals who attended law school outside the state would only get a seat if those seats were available. I'm not as familiar with this restriction. I'm just paraphrasing from her presentation. She argues that this was a deprivation of the 14th Amendment National Privileges and Immunities Clause and the fundamental right to travel. I thought she would have used the 4th Amendment, but she uses the 14th Amendment. She says that individuals may be seeking to become residents in the state where they take the bar exam, or they may have been a resident there prior. And she doesn't believe that this type of unequal treatment should happen as to who gets a seat for the bar exam. So I asked her a question. I said, now, in the state of Mississippi, for the bar exam, individuals taking the bar exam had to sign a waiver that if during the process of the bar exam they contracted COVID, that they would not hold the state liable, they would not hold the bar liable. The bar would just do the best it could in terms of keeping them safe. And she actually said she would find that preferable. She would prefer that, or she would prefer that the bar added an extra test date than to exclude individuals who had studied outside the state. So she made a very interesting argument on this. I tried to push her on a few points. For example, I said, well, New York was dealing with very high COVID numbers. So then does that make what they did, that help it to meet the level of scrutiny, the strict scrutiny you're giving it? But she didn't want to hear that at all. I did send her some follow-up questions about this and about her analysis and whether she's trying to bring back a case from long ago or to even overrule it. So I can't wait to hear what she says. And look, her argument was so passionate. And I'm not going to say it's only because she'll probably be taking a bar exam in the near future, but I believe she probably will within the next year or so. But she also did an amazing job with her position statement on an issue that is very important to so many who are preparing to take the bar exam or to take other professional licensing exams and are wondering if they would be allowed to travel to a particular state to do so. She did great too. Now, we had those three. And then after our break, all of the other presentations for our class meeting, they all were about gender. Now, here is the first one. This is her position. She says the Equality Act should include a provision that allows interscholastic sports, which are gender specific, to be designated based on biological sex, males or females or co-ed or mixed. In other words, she is arguing that transgender individuals who now identify as female, but they are transgender. They were born biologically male, that they should not be allowed, under her argument, to participate in sports as females, that they should be in the category of co-ed or mixed. So she's concerned, she said she's concerned both about women and girls who have to compete against others who may have greater muscular structure. But she said she's also concerned that transgender individuals may be required under some of these laws to take various hormone treatments before they be allowed to engage in competition with females. And she did not think that was right either. Now, she did a very good job on her position, but I had a lot of questions for her. One question was, is there a risk with her position? Is there a risk that this will add to the issue as to, is a woman enough? You know, going back, a woman was not considered woman enough if she wanted to vote. A woman was not a proper woman if she wanted to practice law. A woman was not regarded as a woman if she wanted to be in the sciences. A woman was not regarded as a proper woman if she wanted to drive a car even, or be a firefighter or a police officer. You may say, well, all of that wasn't it 50, 60, 70 years ago, 80, 100? Perhaps, or perhaps not. So my question to her was, would this go down a slippery slope? And my second question for her was, okay, so she's arguing that transgender or intersex individuals should be in a separate co-ed category. I wondered if that was in violation of their privacy rights also, or the privacy rights of all women and men, to have to then prove to someone that they are a woman enough, or that they are a man enough, or just the fact that they are with another group. Does that then reveal certain things about their background, or reveal things about their identity or their bodies, their gender, that they do not care to disclose and assert their privacy rights are being violated? So wow, she did do an amazing job arguing her point and breaking down this complex issue, also addressing Title IX and what have you. But I have so many questions for her, and I can't wait to hear back on those questions. Now, let's go to the next one. The next one was also on gender, and the student's position is this: it is imperative that the Equal Rights Amendment be ratified to ensure continued constitutional rights to all genders. Now, the Equal Rights Amendment missed a deadline back years ago in order to be ratified and added to the Constitution. If you've never heard of the ERA, or the Equal Rights Amendment for Gender Equality, Google it after this. Google it and read about it, because it's going to be much discussed in the, now and in the near future. But her argument is that Congress has the authority. Congress has the authority to say, yes, some states missed the deadlines, but now they've ratified it, and to put in place the ERA, Equal Rights Amendment. And I said, well, do you think the court is going to mess with it? If Congress ratifies it, will the court come back and say that ratification is invalid? She didn't. She said, based on some case law from many years ago, it will likely be what's called a political question, and that the court might stay out of it because it's a matter of Congress ratifying, Congress looking at the ratifications from the states, and that the court may simply leave it alone. My other question was this: we know, going back to Marbury versus Madison, that the court says it is the final arbiter of what is or is not constitutional. So even if Congress goes forward with the ERA, is the court going to then say it is in conflict with some other amendments in the Constitution or some other principles, and diminish the effect of the ERA as to gender equality? Now, I was just thinking about those questions. I don't have answers. I'm waiting for her email to tell me what she thinks about all of that. And she also did an amazing job. Okay, here's the next student position statement. Stringent state regulation of providers of abortions is unconstitutional, as it violates the Due Process Clause of the 14th Amendment. Now she says, wait a minute, we have Roe versus Wade upholding the constitutionality of a woman's right to choose. We also have, in addition to Roe versus Wade, we also have Casey, which reaffirmed Roe, but the states continue to come with more and more laws that challenge the premises of Roe. So she's thinking that perhaps the test for what is constitutional or not needs to be reframed in a way so that we do not continue to see these cases. So I asked her what test is she then going to argue for? What is the test she will argue for? And she said she wasn't sure what that test would be. Now, one thing that I did ask her about is it is not uncommon to see that a court will strike down one law that a state passes, and then another state next door will come forward with the identical law, which ties up the courts, and it also is at great litigation cost to the individual state to be struck down again. Is there some type of way to stop that process? My other question for her is, what if Roe versus Wade is overruled by the US Supreme Court? What if it is? Now, privacy, the word privacy does not appear expressly in the text of the Constitution. But as I said on another clip about the shadowy privacy rights, the court said it's there. Privacy is there in the shadows. But if we begin to restrict it, if we begin to eliminate certain privacy rights, what does it do to the others? If the right of an abortion is no longer constitutionally protected, what happens to the right of married couples to use contraceptives or unmarried couples to use contraceptives? Those rights come out of the same privacy penumbra as the right of a woman to choose. What about the right of non-nuclear families to live in the same household from the Moore case? That right also comes out of this same shadowy penumbra of privacy rights. What about the right of Blacks and whites to marry each other, of people of different racial groups to marry? Didn't it come out of this same penumbra? What about the right of same-sex marriage and relationships? It came out of this same penumbra. So if Roe versus Wade is overruled and privacy rights began to shrink, my question to her is whether she believes other privacy rights will also be eliminated, which means whether certain things are protected or not would depend on the state law. I can't wait to hear her response to those questions. The final position statement, and I think I've done 7. There were 7 great ones. They were all great. I had 7 total. And so this is number 7. Allowing broad exemptions under the Affordable Care Act and implementing a gag rule under Title 10 invades the privacy rights of women and are unconstitutional. So this student was greatly concerned. There was a recent Supreme Court case this year, Little Sisters versus Pennsylvania, which gave the president broad authority to exempt certain employers from providing birth control coverage, and also a gag rule which restricts the rights of how some family planning clinics may be able to operate in terms of giving medical advice to women, if that advice includes discussion related to abortion. And here, in terms of the employers, whether or not the coverage, like for birth control, may be in conflict with an employer's moral or religious view. So she says that all of that is unconstitutional. It is unconstitutional, and it is hitting at the heart of women's reproductive health. And so therefore, she believes it should be struck down. Well, the court is ruled, so she believes it should be overruled. My question I have, though, is what happens when constitutional rights collide? What happens when an employer says, I have free exercise of religion. I don't believe in a woman using birth control. I'm not going to pay for that. And a woman says, I have a right to choose. I have a right to use birth control. I have a right to abortion, and that should be included under my coverage. What happens when these rights collide? What right is deemed to be more paramount than the other? Now, for this student and for all of the final four position statements, and I've typed all of them down in the text below this video for you to consider, I posed them a question. I said, what if in the coming future, the court says something like this? Yes, our interpretations affect the reproductive choices of women. What if the court says this? But women make up 50% of the population. Women are not a numerical minority. So why should the court be bothered with protecting women from the government, from the state, or from the federal government? It is time for women to stop acting like a political or numerical minority. Now, I posed this question, and one of the students who presented responded in this way. The court said the same thing in the late 1800s about Blacks, the late 1800s. Right after slavery ended, the court said, it's time for you all to stand on your own 2 feet. And I guess the rest is history. But what if the court said that in the near future about women? That it was not going to seek to protect women anymore as a suspect or quasi-suspect class, because women should exercise their own political power. What implications would that have for women's privacy rights and for women's reproductive health? Oh yes, there is so much to learn about the Constitution. Remember, learning about the Constitution can bring great enlightenment. Enlightenment leads to justice, or perhaps it can lead to at least a taste of justice. I'm Professor Angela Mae Kupenda. Please subscribe and sign up for notifications. I look forward to telling you more about the fantastic position statements and the learning my students are engaging in. You don't want to miss a bit of this. You don't want to miss even a taste of justice. Thank you. Bye-bye.